People v. Juan Padilla-Zuniga.
Good afternoon. May it please the court. Argon Olgan for appellant. I'm requesting 1 minute rebuttal.
I'm sorry, could you speak up? I don't know if the mic is working, but it's difficult to hear you. Thank you, sir.
Argon Olgan for appellant. I'm requesting 1 minute for rebuttal.
Yep.
Appellant's plea is invalid, and because all of appellant's claims survive preservation, vacatur is required. Firstly, the plea court's failure...
As a threshold matter, what about the the waiver of the right to appeal?
Yes,
How
Your
do
Honor.
you get around that one?
Because each of appellant's claims, Your Honor, are predicated on the voluntariness of his plea, because they rise to the level of constitutional dimension, they survive the appeal waiver.
And then preservation?
With regard to preservation, the Laurie exception would apply firstly to the court's failure to state the mandatory fines at the time of plea, because the court only stated those fines during the imposition of sentence.
And so after sentence was imposed in terms of the mandatory fine, why at that point in time was there no motion to vacate the plea?
Because CPL 22603 prohibits motions to withdraw pleas during the imposition of sentence. The statute says that those motions must be placed prior to the imposition of
Why
sentence.
not after?
I would think that the statute was speaking to finality. Once the order is final, Your Honor, I think that the next step would
So
be
you
appeal.
could not bring a 440 to vacate the plea and sentence based upon the fact that he was not informed of the fine?
Because of the fact that the omission is on the record, and because that lies as results as a per se defect, because the court failed to state that fine, then 44010 is precluded because that would require because it's on the record and that it would be before the appellate court.
And
for
no
appeal.
requirement that the attorney at the time of sentencing, where the court says that it is imposing the mandatory fine of $500, that at that point in time the defense attorney says nothing?
I think, once again, the time would have passed for a motion to withdraw a plea.
Oral. You know, I noticed that in your papers, but not all objections have to be in writing. I mean, you can have an oral objection on the record. So at that point in time, where the judge says, and the mandatory, the mandatory fine of $500 plus applicable surcharges are imposed, why at that point in time could the attorney not say, wait a minute, Judge, this was never mentioned, this was never discussed?
My answer to that is twofold, Your Honor. First, the only recognized way to object to an invalid plea is a motion to withdraw the plea. The defendant would have to actually say that he wants to withdraw the plea. And that goes to the heart of the Laurie exception, I think,
At the
Your Honor.
time that the court has now pronounced what the fine is, the court has completed sentence. So does that go to whether the defendant at that point would have had a reasonable opportunity to preserve in the traditional route?
That's exactly correct, Your Honor. It
So
goes to
if we agree with you about the fines, do we have to address any other issue?
We would not, because the invalidity of the fines would implicate the entire plea bargain. It would go to the defendant's decision-making at the inception of the plea.
That may be true, but just for purposes of filling your time, what about the allocution on the aggravated unlicensed? How is that properly before this court?
It's properly because once the defendant denied having a license and stating that he never had a license, he was saying no to the question of the court as to whether he had a suspended license. That is a direct negation of the essential element of driving with a suspended license under VTL 511. The error was now properly before the court, because once the defendant is essentially protesting his guilt before the court, it becomes the court's independent obligation to secure a valid plea by asking further questions.
But his attorney, first of all, how does that negate an element of the crime? And two, his attorney specifically says, well, isn't it true that you're privileged to drive a motor vehicle? You do not have a privilege to drive a motor vehicle. And he said, no, I don't have a license. I never had a license.
The first question was a direct question. Were you driving with a suspended license? The defendant's direct answer was no.
No, I never had a license.
Yes, and that was his second answer, essentially doubling down on his negation of the first question of, did you drive with a suspended license?
And what was the next question
The next question?
after that second answer? Because I believe, if my recollection of the record is correct, the court just went on to a completely different topic
Yes.
after he said, I never had a license.
Yes, and that's the error of law, which is a fundamental part of our
So
claim.
you're saying that's the juncture at which the court had to make the inquiry?
Yes, and if the record was devoid of any follow-up inquiry by the court, then at that point, the significant doubt as to the appellant's guilt remains.
So I just want to go back a step to when you said that, when he said, I never had a license, I feel like you're almost arguing that that's tantamount to an objection, in the sense that it puts the court on notice that there's something wrong with the plea? Is that, can you just articulate what the reasoning is behind how making that statement preserves the issue?
It does, because at that point, the defendant is essentially making an argument that it is a factual and legal impossibility that he had reason to know that he was driving with a suspended license.
So
The
although he
defendant-
doesn't know it, he's saying to the court, you can't convict me of this crime because I wasn't driving with a suspended license. I never had a license to begin with.
I think that regardless of what the defendant was thinking, it's on the
So
face of the record.
is that essentially saying he didn't have the privilege to drive in the first instance? Is that different from having a license in the first instance?
Yes, I think there would have to be something on the record to show that the defendant had reason to know that his license had been suspended, and that's where the court was to come in and to ask, well, you never had a license, so you're saying you never had a license, so were you contacted by DMV, for instance? Were you notified? Something to clear up the confusion. And if, in fact, the defendant continues to protest, then the defendant is essentially saying that he's not guilty and refuting
So
the
you're
factual
saying the
allocution.
court failed to fulfill its obligation to inquire further?
It has an independent due process obligation to secure a factually sufficient allocation, and when the negation is so evident on the record, it does become the court's obligation regardless of preservation.
So I'm back to preservation now. So at that point in time, that's the plea, but before sentence, why is there no motion to withdraw the plea at that point in time? Prior to sentence, because this has already occurred. This occurred at the plea, right? So the argument is that he should not have pled to this crime because the elements were not fulfilled. Why now is there no motion to withdraw, because we're before sentencing?
Because I still think that with the factual allocution, Your Honor, I still think that we're left in that position where we're not quite sure what the defendant is thinking. I mean, on the one hand, we have this very evident statement that he is confused. He's stating that he might not have known about a suspended license and making these statements. But we don't really know what the defendant's decision-making is yet. It would have only been resolved if the court came in and asked those questions.
But
And
that
then maybe-
answer, it's somewhat unsatisfying in that you previously responded to Judge Weber that, just raising an objection in itself is insufficient in this context. Your remedy, if you're a defendant who's taking an improper plea, is to move to vacate the plea. And I think the judge is pointing out to you that there was an opportunity here, because that error happened at the allocution, not at the sentencing. You had the opportunity to do what you said is necessary, which is to make the motion to vacate the plea, but you didn't avail yourselves of it.
Let me frame it this way, Your Honor, if I may. I think that the two errors are separate. I think that with regard to the court's failure to state a mandatory fine, that goes to the defendant having the opportunity to make a fully informed decision before going into the factual allocution. And the only way to respect the defendant's decision, if I may finish.
So negating an element of the crime is somehow an error of a different category than
Yeah,
not being fully informed about the direct consequences of your plea.
Yes, Your Honor, and if I may, I know my light is on. That goes to the court's responsibility to enter in a factual allocution of guilt. And when there's a negation of that factual allocution of guilt, the entry of the guilty plea, even if the defendant says, hey, I want to enter guilty, I would say is fundamentally erroneous.
Thank you.
May it please the court. My name is Kevin King. I'm representing the respondent, Nassau County District Attorney's Office. There were, of course, deficiencies at the plea proceeding, and that's on the record.
Isn't the failure to inform the defendant of the fines reversible error?
Well, yeah, it's an enhanced sentence error, and it would be reversible if defendant had preserved it, which he didn't. If defendant had called the court's attention to that error, the court would have had an opportunity to
Once the
correct
court
it.
announced it, at that point, you had to say, wait a minute, you didn't tell me about that.
Right.
Isn't our case law to the contrary?
Is that a meaningful opportunity to, you have to do it instantaneously?
Well, in this case, again, yes. I mean, I think it's not an onerous or unreasonable burden to expect a defendant who's represented by an experienced and competent defense attorney to alert the court that the imposition of a monetary fine that the defendant was unaware of and that would change the defendant's plea calculus, to alert them when that occurs. I mean, that is something that's actually been recognized in the appellate divisions. The appellate divisions have rendered decisions which state that defendant's claims regarding an enhanced sentence where a fine was imposed that hadn't previously been announced at the plea proceeding was unpreserved, and they didn't reach the issue. So the concept that a defendant, again, represented by counsel, that's the opportunity to call attention to the court, call the court's attention to the problem, again, is something that other courts have recognized. And we can distinguish it from Lorry and Turner, because I think the key language in those two decisions is that, in Lorry, it was said that a defendant can hardly be expected to move to withdraw a plea on the ground of which he or she has no knowledge. And in Turner,
So when the court announces that it's imposing this fine that was never spoken of, the court is imposing it as the court pronounces it. How is that a reasonable opportunity when the court is completing the sentence as it's speaking?
well, again, we're talking about a monetary fine, which is something that people understand. That's not an esoteric legal concept that you have to be a trained attorney
No, but it's
to
a
understand.
concept or something that the defendant was unaware that he would be responsible for. He was told that it was 5 years probation. He was not told that there would also be a fine. So we know what a fine is, yes, but he was unaware of the fact that he would have to pay these monies as well.
And I believe there's a tension in defendant's claim in that regard, because this is a mandatory fine. It's in the VTL. You have
But that cuts both ways. Why is it that the court, if it's mandatory, it's going to be imposed if you're the court, or even the people in that case, but, why isn't that something that defendant could have known about at the time that he was entering into the plea agreement?
Well, the court should have informed him
Absolutely.
during the plea proceeding. That's why it was an enhanced
I
sentence
thought
error.
the
It is
PRS term in Turner was mandatory also.
Right.
Right.
And I thought in Turner, correct me if I have the timing wrong, but I thought that the defendant learned about it during the course of the sentencing hearing, and that it was determined that that was not early enough to allow the defendant to do anything about it. Am I wrong about the?
No, that's correct. And if I may,
Why isn't, go ahead, please,
if I can distinguish it,
please.
I think, again, in this case, we're talking about a monetary fine, which anyone, even a layperson, understands what $500 is.
How does that?
That doesn't have to be explained to somebody.
Tell us, if you would, how does that play out? Does that mean that mandatory fines don't need to be disclosed?
No, again, it is an enhanced
Right.
sentence error, absolutely.
Okay, so I'm not sure if, Turner may be different in that regard, but I'm not sure if it's a meaningful grounds to distinguish the case. What about the timing?
I believe it is, well, if I could get to the time, because I think this relates to the timing. Again, this is not a discretionary enhancement, it's not restitution, it's not something
But so too in Turner, right? It was mandatory PRS, I believe?
Yeah, that's correct. But again, I think the distinction here is an important one. With Turner and Lorry, it was a Cat 2 error, failure to advise on PRS, which was, first of all, it's a much more significant deprivation of I think, a defendant's rights than the
But
imposition
you
of a fine.
acknowledge that it was error and it enhanced what he was being exposed to. You're saying because it's money, it means nothing? For someone who is impoverished?
No.
It does matter.
Yes, absolutely it does. But my distinction, if I can, is that this is something, you have an experienced defense counsel. This is an experienced legal aid attorney who was representing defendant.
And that was different in Turner?
But if I may, Your Honor.
Okay.
This attorney takes pleas of this type all the time, certainly would have been aware that there's going to be a fine imposed. That is done in every single 1192 case, every single 511 case, because it's mandatory. This creates a certain tension, which I'd like to get to in a moment, but with the ineffective assistance of counsel aspect of this claim.
So the
But
onus is on counsel, not the court. Is that what you're saying?
I'm saying I think it's reasonable to expect that a defendant, again, represented by counsel, when they hear of a fine being imposed, a mandatory fine being imposed, can make that court aware that error is occurring and call their attention to it.
That's true for the other cases.
And the distinction, Your Honor, is that in the Catu case, I would just argue, it's a very specific and kind of unique error. It came about because there was a change in the law where post-release supervision was made mandatory. And there was a period of time where there were a tremendous number of cases when even defense counsels were unaware of the fact that this needed to be pronounced. That's why it's recognized by a name. It's an error that has its own name recognition because of that. And in Laurie, I believe that was 2 years after that Cat 2 error was first recognized. And in Turner, it was somewhat later, I think in 2014. But nevertheless, I think there's a distinction between.
But nothing in the cases supports this view that the decision was discrete and isolated to a Cat 2 problem. Not a word.
No, but I think
There's very broad language in all these cases.
But I think what it goes to is what the cases in Laurie and Turner said, which is where it's an error in which a defendant would have no knowledge or would not be aware. I think there's an element to the Cat 2 error where we can
Counsel, you keep
understand.
saying that, but what my response is when I hear you say is, yes, everyone knows, people know about fines. That's not interesting. But what this defendant didn't know, or there's a good possibility that he didn't know, is that a fine would be imposed on him as a result of this conviction, unless he read the VTL or something else, which we don't presume that he did. So that's the problem, not the existence of monetary fines.
Well, I understand that, but again, it's difficult to understand on how that error would occur, again, if counsel is confident at all.
But it did occur. You say it's difficult to understand how it would occur, but it did occur.
Well, it isn't difficult to understand if the plea is voluntary. One reason that the counsel wouldn't have brought this to the court's attention is because counsel understands the defendant wants this plea. It's a plea without a jail sentence, which might be what he wanted.
And in Turner, I believe the defendant wanted a plea as well. But again, there was the failure to inform the defendant of the post-release supervision. Now, in this case, I will say, I believe that the defendant had a prior 511 in 2016.
That's correct.
So are you arguing that he knew there was a fine, a mandatory fine, because when he pled guilty to the 511 in 2016, a mandatory fine was imposed?
Well, I don't think we could, unfortunately, we can't know what defendant knew.
So it seems to me that what you're asking us to decide is that mandatory fines don't fall within the Laurie Turner line of cases, that they're different in kind than PRS.
In essence, yes. My argument
And
is.
so why is that? Why should we treat them differently? You've said that PRS is a more significant intrusion on liberty. Is there any other reason why we would exempt them from that line of cases? The fines, I mean?
Because it's such a simple, it's something I don't think it's unreasonable, again, to expect that when a defendant appears in court for sentencing alongside an experienced attorney, and such an obvious enhanced sentence error occurs regarding condition of defendant's sentence that even a layperson would understand.
But why is it not reasonable to expect that the court, who has taken pleas on a regular basis, would not properly do it?
The court should have.
And that the onus is then on the defendant. But you're suggesting, well, the defendant just should have known.
Right.
The
So-
court made a mistake, but the defendant just should have known.
And
Well, I think
where is
defense
there
counsel
any
should have
case,
known.
where is there any case that says because a defendant should have known what the sentence, what the sentencing could be, or what the sentence in terms of a mandatory surcharge, that the defendant does not have to be informed of the same?
I think defense counsel should have known, and I think if defense counsel didn't inform defendant that it was a mandatory fine, then defense counsel was ineffective, and that's defendant's claim. I also,
So he should go to his attorney and ask for the $500.
I think the defendant can make a motion under 440, or defendant can argue on appeal that the counsel is ineffective for failing to inform him that a $500 mandatory fine would be a part of his sentence, and it would be such an important issue to the defendant that it would have changed his plea calculus and rendered it involuntary.
So do you agree with counsel that when the court announced the $500, it was then too late to withdraw a plea?
I wouldn't say it was too late. After that happened, counsel was able to request from the court that defendant be given time to pay fines, so there were further exchanges that
When is
occurred.
sentence complete?
Well, sentence was complete when it was pronounced. But again, the issue here, it's still possible to call the court's attention to the problem. The court can, if it's pointed out to the court that they very clearly enhanced the defendant's sentence, it's a clearly reversible error.
And that, okay, all right, let's go with it. Lawyer says, oh, wait a minute, you didn't tell him about the fines. What would have happened?
Well, I'm sorry.
What?
If you could
Right,
repeat, Your
I
Honor.
thought your response in part to the Chief Judge's question was, yes, there was an opportunity because the lawyer could have said something at the time of imposition of the sentence, even though sentencing is complete upon announcement of the sentence, right?
Correct.
Okay, so if the lawyer then says, oh, Your Honor, the fines were never mentioned during the plea, this is the first the defendant hears of this, what
And-
would have happened there,
And
just to be clear?
the plea is involuntary for that reason.
Uh-huh.
And if the court takes no action at that point, then I think that defendant on appeal can make that
You're saying
argument.
the judge should construe that as a motion to withdraw the plea?
I think the judge can certainly
To
vacate the sentence.
Vacate the conviction?
The judge can vacate the sentence if the judge if it's made apparent to the judge that a very clear and obvious reversible error has occurred. And again, now we've eliminated the preservation issue out of it because that's been called to the court's attention. So again, and that's what we want. That's what we want because we want that to be resolved right then and there. We don't want to have to go up to the appellate division and then ultimately the Court of Appeals to resolve these kinds of issues. That's the whole purpose for the preservation requirement. And it also, again, there is also an interest of justice jurisdiction. So
And if the lawyer doesn't do what we're talking about, doesn't realize it, why not just let it be raised on direct appeal rather than having these separate motions? Seems a great waste of judicial resources and putting an undue burden on the defendant.
Well, again, the most direct way to resolve this is to bring it to the court's attention, all the defendants in the courtroom, and if that's something that can be done, I think that's a sufficient preservation of that argument. If the court's not responsive and says, I don't want to hear it, well, then I think then you have no choice. Now you have to go to the appellate division. But the reason that preservation matters and that we enforce preservation rules is because it's in the court's interest and everyone's interest to resolve these issues at the first instance when they can be. We don't want any undue delay. And again, if counsel says nothing, and defendant says nothing, and then goes to appeal and says, well, this is a lower E exception, where was counsel's role here? And again, there's one explanation for this is that the reason that there was no objection is because, again, counsel was well aware that the defendant had no intention of withdrawing his plea, that he was satisfied with it. And again, that would be competent representation. So, And lastly, again, I just will touch on it quickly. I mean, this is what the interest of justice jurisdiction from the appellate division is for. If defendant
Which
can go.
does not have to be exercised if the appellate division chooses not to do so.
If they choose not to, but if a defendant in this situation can make out a case that I was prejudiced, I would not have pleaded guilty but
But
for
they
this
still
fine.
don't have to exercise it.
They don't have to, but again, it's another way. Again, it isn't as though, if defendant fails to preserve it, he has no argument to make. That argument can be made. And in this case, the appellate division did not reach this issue in the interest of justice. And that the reason for that must be presumed because they did not perceive anything in the record that suggests this is actually an involuntary plea.
Thank you.
Because there is nothing in the record to suggest that.
Thank you. Got your point. Thanks.
May I, Your Honor, if I may request, just in 1 minute, just to address the
No,
issue.
sorry, your time's up. Thank you.
Just
Counsel,
brief,
can you address this last back and forth that we just had regarding what would have happened if the lawyer had realized, once the sentence is imposed, once the fines are announced, if the lawyer had said, Judge, you did not raise the fines issue during the plea, as the first defendant hears of it?
I think we could only speculate. I think that quite possibly the court may have said that I've already imposed sentence at this point, and your defendant's time to move to withdraw his plea has elapsed. I think that with regards to speculating as to what defense counsel may have done, should have done, thoughts about strategy, the reason why we have the per se defect rule is because we focus on the defendant's decision-making throughout the entirety of the plea. First, during the plea allocution, if there's an omission on the record of a mandatory fine, the defendant's decision-making is essentially cannot be knowing at that point.
So is that your response to the prosecution's assertion that a learned defense attorney should have known better?
I think that even if we were to assume that a learned defense attorney should have known better, because the per se defect rule requires an on-the-record analysis. Either the defendant knows or he doesn't, and we look at that from the omission of the fine on the record.
So, counsel, you're only asking for the vacating the 511, is that correct?
We're asking for vacatur of all the convictions because the court's failure to state the mandatory fines with regard to both the 511 and the 1192 implicates the entire plea bargain.
So he gets an opportunity to renegotiate the entirety of the plea?
Yes, upon vacatur, it would take us right before the
And so
plea.
he finishes probation in a little over a year, July 2016. So everything goes back, and he's going to be prosecuted again for these charges. If he's already paid the fines, then he doesn't get a credit, so he starts all over again.
Well,
right?
yes, except the plea-based convictions are now vacated, and he goes back without those plea-based convictions on his record for the time
Right,
being.
but he will be prosecuted again. He's subject to he's still subject to prosecution on these charges.
We would assume that there might be let's assume there is prosecution. It is still the defendant's right to avail himself of his constitutional claims, as we have done today, and to go back to that time prior to the plea.
Thank you.
Thank you.